and he exhausted.
The two are not entirely unrelated. I mean, in both cases, your claims are going to be based on the denial of an FAPE or a FAP, and it's certainly reasonable to assume that the settlement process under the IDEA could well be significant in resolving the other claims. It seems to me that what's unusual in this case is that the school board said, well, don't worry about those, we're going to settle this. I mean, if this were any other type of litigation, the lawyers would want to say, we've got a lot on the table and let's figure out how to resolve it. And it's not clear to me why you would necessarily or artificially separate those two. And of course, your friend on the other side has a construction answer to your notion of how the exhaustion works. The relief you're seeking is based on a FAPE. That's what's going to be pertinent in all those cases. Why isn't that?
So 2 points to that, Your Honor. First of all, I think it's certainly true that if you bring the IDEA claim, you could have a settlement discussion that encompasses not just the IDEA claims, but also other claims that you might have that haven't yet been asserted in that process. And I think the normal thing that we would expect is that when parties are bargaining, and if the child is going to give up those other claims, they're going to get something in return. In this case, that settlement discussion happened. There was a settlement discussion, and Miguel would have turned down a request to give up ADA rights without any compensation for those ADA rights. And the effect of Sturgis's rule is that if he accepts the settlement on the IDEA claim, it automatically gets rid of, it essentially gives the school a full release, a get-out-of-jail-free card on the ADA liability. And that's just not right. And I think the second thing I was going to say, Your Honor, is that this isn't an artificial limit. This is a limit that comes out of the text of the statute. And Congress was very clear. It chose words very precisely. And it said that it made clear you don't have to exhaust if the relief you're seeking in the non-IDEA claim is not available under the IDEA. And I think in these circumstances, it makes sense to read that language the way you would look at the same words elsewhere in the IDEA. The same word relief appears elsewhere, and it means what we say it means. That's the way the word relief is used in other legal contexts. That's consistent and I think reinforced by the reasoning of Frye, which says that if you have to go to the hearing officer and the hearing officer would necessarily turn you away empty-handed, we don't want exhaustion in that circumstance. This court's decision in Carr versus Saul announces the very common sense principle. This is 2 terms ago, saying that it makes little sense to require litigants to present claims to adjudicators who are powerless to grant the relief requested.